Earlier this week, a class action lawsuit was filed by 4 Arizona same-sex couples who claim that the state's ban on same-sex marriages is unconstitutional. Shawn Aiken is the attorney for the plaintiffs and attorney at least. Are you the lone attorney or are there others involved?
My daughter is co-counsel, Ellen Aiken, and associates from my office, Heather
All right.
Macri and Will Knight.
All right, good enough. So you are very much involved. It's good to have you here. Thanks. I would have liked to have gotten into debate, but it's kind of hard to find some folks on the other side as yet. They're still kind of formulating whatever. That being said, what's going on here? What's the relief petitioned here?
The relief is for an injunction against all the laws that discriminate against same-sex couples and keep them from getting either married here or having their valid out-of-state marriages recognized.
And these are 4 couples? These are Arizona couples?
Yes, there are 4 Arizona couples, 3 in Maricopa County and 1 in Pinal County. Yes, longtime residents.
And these are longtime residents, but were they married in other states?
2 were, 2 were not. The 2 who were married in California in 2008, yes.
And again, I understand the Supreme Court ruling on federal benefits is a big factor here. Talk about that ruling. Talk about how it factors what you're trying to do.
That ruling came down in June of last year. It's called United States versus Windsor. And in the Windsor case, the U.S. Supreme Court struck the Defense of Marriage Act provision that banned federal benefits to same-sex couples. And our argument here is that for the same reason the federal government could not prohibit couples from receiving those benefits and ban marriage between same-sex couples, so too the state cannot do that. And so we're asking for an extension really of the Windsor ruling is the way to look at it.
Okay, and this Arizona not the only state going this route, correct?
Arizona is one of 32 states that currently ban same-sex marriage, and I am aware of cases in about half of those that are challenging those laws. So we're about number 15 or 16.
Critics of the move will say that the voters of Arizona did amend the Arizona Constitution to include the definition of marriage being of a man and a woman.
Right.
Done by the voters, Constitution amended. We can get into the court cases afterward here in a second or so. Mm-hmm. But how do you respond to folks who say, you know, this has already been addressed and the people have spoken?
Well, first of all, the people spoke in 2008. That was before Windsor. And secondly, Ted, it's never been the law in the United States that voters can pass discriminatory propositions. So the fact that the voters of Arizona said or did what they did in 2008 doesn't make it any more defensible than what the legislature did in the late 1990s. So I understand the point, but the amendment doesn't make it any more defensible.
Talk about the Court of Appeals ruling, though, in 2003, which seemed to uphold the definition, and it seemed to say that lawmakers can decide that it is in the state's best interest to keep marriage to a man and a woman. How does that factor into all this?
Well, that was Danhart. That was a very narrow ruling. Mm-hmm. We don't need to get into the legal weeds on it, except to say that it came before the state constitutional amendment. It came before Windsor, and it's not an important consideration for us in our case. We're looking solely at the laws, the statutes, and the state constitutional provision only.
And again, from the other side, the critics will say if you are looking only at statute, why not go to the legislature? Why not get the voters to address this again? Because it's been done in other states, and in other states, sometimes it succeeds.
Because my clients are suffering. And without some relief from a court, the legislature is not going to act.
Right now, the 10th Circuit, is the 10th Circuit taking up the Utah case? Is that correct?
The 10th Circuit is receiving briefs in the Utah case.
Talk about the Utah case real quickly.
You bet. The Utah case is very similar to ours. It's in federal district court. Judge Robert Shelby struck Utah's ban on same-sex marriage, and that's now on appeal to the 10th Circuit. He decided that in December. Briefs will be done in February, and the decision will follow, I would think, in the spring.
Again, the question, why not wait for that decision?
Well, 2 reasons. One is the 10th Circuit could reverse, And secondly, what happens in the 10th Circuit doesn't govern here in the 9th Circuit where Arizona is in any event. So I have clients who are looking for relief and looking for an answer, and so we're in court here in Arizona.
Does it seem as though, regardless of where it goes, the avenues taken, this is going to wind up in the U.S. Supreme Court?
I don't think there's any question about it. All the authorities, people who know this issue a lot better than I do, agree that sooner or later the Supreme Court is going to have to resolve this issue, namely, how will state legislatures and voters in the states be allowed to treat this issue? Yes.
And I mentioned earlier the idea of going to the legislature, and some would scoff at that idea, but the fact is it is an option. Is that even a consideration as far as folks who, same-sex married couples who are looking for relief, but looking for relief perhaps outside of the courts?
Well, it's certainly an option, and I'm probably not the most informed member of the community on that question. I do know, in getting ready to file this lawsuit, that the question has come up in the Arizona Senate the last two sessions. I think Senator Gallardo, I believe it was, the last session had a proposal, but it gets nowhere, and so the question is, why wait?
And so what is the timetable now for your suit?
We expect responses from the defendants of one stripe or another in February, and for reasons that will be beyond my control, namely a very good judge and very able defendants, I can't say for sure how long it'll be to resolution. I hope in 2014. The Utah case was 10 months.
Yeah.
Complaint to result March to December. So.
All right. And again, as far as the 10th Circuit is concerned, you're saying 9th Circuit obviously is independent of the 10th, but you do get an indication, you do get a hint, you do get a suggestion of where this thing is headed.
I think that the law is changing in my client's favor. There's no question about it. And the Utah case is an indication of it. Yes.
All right. Shawn, it's good to have you here. Thanks
It's
for
very
joining
good to
us.
be here.
Appreciate it.
Thank you.